Welcome to Off the Record, a legal podcast.
Hello and welcome to Off the Record, a legal podcast with attorney Rhett Burney. I am your host, Kevin Rosenquist. In today's episode, we are going to discuss the crucial medical documents everyone should have in place to ensure their healthcare wishes are respected. From healthcare powers of attorney to living wills and DNR orders, experienced estate planning attorney Rhett Burney will break down these vital documents and explain why they're so critical. Rhett, thanks for being here. Excited to chat with you again.
Yes. Kevin, how are you feeling today? You feeling healthy?
I feel super healthy. Yeah, I feel great. Got a good night's sleep. Everything's good.
Well, we're going to talk about what happens when you don't feel it.
Oh, okay. All right. Well,
you know what? You don't feel anything at all.
It's good. It's good to be prepared, I guess.
Yes, always be prepared.
What are the risks of not having estate planning medical documents in place, especially when you're talking about an emergency or a health crisis?
These documents really are to help your loved ones make decisions in difficult situations. So, for instance, let's talk about a healthcare power of attorney. And with a healthcare power of attorney, what it does is it, one, authorizes someone to make healthcare decisions for you if you're unable to. And then it also talks about how you want the end of your life to occur if your health situation is at a state where you're going to die within a reasonably short amount of time because of your current health situations. And what these documents are great because, you know, the situations I see, you're at a hospital, dad or mom is dying, the palliative care people, the doctor comes in and they say, okay, you know, we've got this, you got your loved one on life support. We can keep them there. There's not going to be any quality of life. The outlook doesn't look good. What do you want to do? Well, this document goes ahead and it says, hey, Rhett, let's say I'm the one dying in the situation. Rhett wants this. Rhett doesn't want that. And the reason that's good is, one, your loved ones know what it takes pressure off of them, right? They don't have to make that decision. But I have personally seen, Kevin, in that situation, not as the person dying, but I've been in there with loved ones where, you know, wife says, I don't know what to do. Son says, pull the plug. And daughter says, don't kill my dad, right? What happens in that situation when that document doesn't tell them what to do? It takes a lot of pressure off the loved ones. The last thing you want to do is to leave your family fighting because you didn't plan properly and give them directions how you wanted your life to end in a situation where medical decisions have to be made.
Yeah, and it's easy to think like now, like, oh, well, you don't want your family to suffer, you don't want this, but like in that situation, when it's your decision to make, or when it becomes your decision to make, if there's not proper planning in place, then who knows how you're going to feel in the moment.
Yeah. And then selfishly, if we get to choose how we want to get out of this world, you know, in a situation, you know, it's not a car wreck, you die immediately, but in a situation where it's a progressive decline, if you get to make that decision now and you have control over it now, why not go ahead and make it known now? So those who are in charge of your life or the end of your life know what to do. And, you know, as humans, we don't like to think about the end, right? We think the end is way down the road. It's never going to happen. Or when it does, it's going to be instantaneous. That doesn't always happen. It just doesn't. And humans, I heard one time, Kevin, that humans are the only creatures that know the end is coming, but yet do nothing to prepare for it.
That's a good line. I like that. Can you explain, I'm sure we've talked about this before, but can you explain the difference between a living will and a healthcare power of attorney?
Yeah, so with a living will, so you can do one or the other, right? You can do both if you want to. A living will, where I live, it just says, okay, if my medical condition is such that I'm going to die within a reasonably short amount of time as determined by the doctors, I want life support. I don't want life support. I want to make this person make that decision for me. That's a living will. They should call it a dying will, but it's a living will. The healthcare power of attorney is more robust. It not only deals with the end of life situation, but also deals with that situation where you're not dying, but your health is bad and you can't appreciate it because you are so sick. And it allows someone to say, okay, let's put Kevin into a rehabilitative center, for instance. Let's make sure Kevin has this surgery that he needs because you're unable to express your wishes or you're incompetent and can't appreciate what needs to be done and therefore can't express your wishes. Does that make sense, Kevin?
Yeah, for sure.
I recommend the healthcare power of attorney over the living will just because it's more robust. Why pay for two documents or one document that doesn't do what you need it to do when you can same amount of work can do more than what one or the other does.
You mentioned that you can do both. Are there certain situations where both make sense, or is it kind of unnecessary to do the living will if you do the healthcare power of attorney?
I think it's unnecessary if you do the living will, if you do the healthcare power of attorney. Plus, there's always that chance of inconsistencies. Usually in our documents, we say this document would override the other document, but why go through that battle of having to have a court make that determination, or people fighting about that? Just do one, stick with that. And if you have questions about those types of documents, an experienced lawyer will be able to go through all the scenarios with you of what to expect. A good lawyer can add some real life application to it to tell you what it looks like, rather than just, hey, here's a dead document. They can give some life to it by the explanations of how they can show you how it would be treated if something happens.
In what situation would someone prefer a living will to a medical power of attorney, or is it cheaper? Is there any real benefit to doing that instead?
Remember, with a healthcare power of attorney, that allows someone to make healthcare decisions for you. The living will is just limited to the end of life decision. So
okay,
if they don't want someone to make healthcare decisions for them later on, then do the living will. But what's key in all of this, if you're cognizant and can make decisions for yourself, you're still going to be able to do that with a healthcare power of attorney and a living will. They go into effect when you can't make that decision, either because you just physically or mentally can't.
That's a really good distinction, because if you're laying there and you're like, oh, no, I want to do the surgery. And they're like, no, I'm in charge. You're not doing the surgery. We're pulling the plug on you.
Yeah. Or you're in there and your wife says, pull the plug. And Kevin's like, no, don't pull the plug. I'm still here. So yeah, you still keep control over it.
Pull the plug. I'm just here for a physical. I'm fine. What else is included in a living will? Is it seriously just the end of life, or is there more stuff involved?
End of life.
It's just end of life. Okay.
Yeah. Let me clarify that. So the ones we do, they have two options, right? You want food and hydration to be provided to you. The other option is, do you want life-sustaining treatment and procedures to be provided to you? Mm-hmm. What people worry about, they say, what happens if I had a heart attack and I need open heart surgery? Well, the living will is not going to take care of it. The healthcare power of attorney is not going to take care of it. It's not going to say, oh yeah, Kevin didn't want surgery. No, that's not what's going to happen. This is if all the medical treatment has been given to you and you're going to die within a reasonably short amount of time. It's not where you have to be put on life support because you're having open heart surgery and you have a machine having your heart beat for you. That's not where it's going to be happening. It's the end of life. Now, the healthcare power of attorney can give someone the ability to make healthcare decisions for you, but again, that's not going to be applicable where you're having to have a required surgery.
What role does the Do Not Resuscitate, the DNR, play in an estate plan? Is it something that everybody should put into their estate plan?
You're going to have a doctor. Where I live, you have to have a doctor sign off on it. Usually you're going to have some type of medical condition that would necessitate that. I don't push those, really. I don't push those. As you get older, maybe, you're so sick, and why prolong it? Mm-hmm. I would say probably look at it then. But, for most people, the DNR is probably, I would not put that as one of your priorities in an estate plan.
So it really, you look at it as more of something for someone that maybe have gone through a lot and is like, all right, this is it. I'm not doing any more. So if this happens again, just let me go. Yeah.
If somebody who's really, really sick, I don't want to say on death's door, but they just don't want their health is such that they really don't have a quality of life. And you get your doctor to say, yeah, Kevin, if he has a heart attack, don't bring him back because he's got other issues that I don't want to say it's not worth it, but you don't want it, right? You don't want it.
Yeah. That's interesting. So it's the difference between that and a living will would be that you're talking about okay, we could bring him back with CPR or whatever, and he doesn't want that.
Yeah, that's right.
Whereas a living will, you have to kind of that doesn't count for that. If they can bring you back, even with a living will, they're going to bring you back.
Yes. Yeah.
Okay. That makes sense.
Let's clarify that a little bit. It's really fact specific, Kevin.
Okay.
We always talk in general terms, but
sure,
we can get into the specific facts of that. So if you have a living will and it says, if the doctors say I'm going to die within a reason, you're already on life support, really. DNR is don't provide it at all.
Okay. And with a medical power of attorney, so if you don't have a medical power of attorney, And you made that, you told that story of like with the mother or the spouse doesn't know what to do, the son wants to pull the plug, the daughter says no, don't kill my dad. If you don't have that medical power of attorney, no living will, none of that stuff, who makes the final decision? How does that work?
The state I live in, and this may be applicable in other states, we have an Adult Health Care Consent Act, and it sets a hierarchy of who can make those decisions for you. Obviously, a spouse is going to be ahead of a child, and there's just a long list of that. But the main thing about that healthcare power of attorney is it tells that spouse who may have priority to make that decision, it tells them what you want that decision to be. So when they are explaining it to loved ones, why you decided to pull the life support, you can say, because your dad wanted that to be done. You don't have to then have, people are different, right? And you may have someone that just is going to hold it against the spouse who pulled the life support, thinking, oh my goodness, you killed my father. No, a healthcare power of attorney said, this is what your dad wanted.
And you said there's a list of people that go down the order. So if the spouse, when would you go down to the next person? If the spouse can't make the decision or the spouse doesn't want to make the decision?
That's a good question. Obviously, but if the spouse can't, maybe there's a car accident and they're beside you, or maybe they just don't want to make that decision. That becomes a little more troublesome, especially when you're dealing with the hospital who has to be the one to take life support off or not. They may say, look, we're not going to do anything. Y'all got to go figure this out and then tell us. Just because of the liability.
Oh, I was going to say, yeah.
They're afraid of it. I've represented hospitals, still represent hospitals, and we've had to deal with that. And it's tough. It's tough because, all the medical professionals know what should be done, right? They just know this person's body's just it's not coming back. But you have a big fight in the waiting room between the children and the spouse, and hospital's going to say, y'all go figure it out and let us know. They're not going to go Adult Health Care Consent Act and say, yeah, we're going to follow this. They could, but they don't want to get into that litigation either. So that's why it's better to have it pre-planned rather than having to wait on the law. Because if hospitals say, y'all go figure it out, go file a lawsuit and get in front of a judge. We've seen cases in the past where families are fighting over whether to take a loved one off of life support. Do you really want that to be how you go out? Bad way.
Yeah, you're right. From the standpoint of the person who's dying or on life support, like, yeah, you don't want to leave your family in turmoil because they've had to make this horrible decision.
Sure. That is the number one reason I think is why you have these documents. Just so you're not, it's kind of selfish if you don't, I think. And they're really family preservation documents, really. They're not just a living will or a healthcare power of attorney. They're family preservation documents.
That's a good way to put it. Can a person update or revoke a healthcare power of attorney or living will if preferences change over time?
Yeah, all the time. And we have people do that all the time. So absolutely, once it's done, it can be changed.
What kind of reasons would somebody want to change things?
They may go through a divorce, right? And they don't want that person who can make healthcare, their ex-spouse to make healthcare decisions. They don't. We have laws in place to take care of that, but not everybody shows up at the hospital with a divorce order saying, I'm no longer can make these healthcare decisions. Wouldn't that be a way to get back at somebody?
That would be the ultimate way to get back at somebody.
That would be the ultimate way. Yeah, and their whole view upon death may change, right? There's various reasons, but for the or the person that they named as the person to make the decision for them, if they could, they may no longer be around, or they may not like them, or they may not be responsible enough. So, people come in and out of our lives, and some relationships get better, some get worse. If those relationships tend to decline, that may be a reason why you want to change the person who's making healthcare decisions.
And how do you recommend people get started? What kind of plan should they have in place before they come talk to you? What kind of questions should they be asking themselves or their spouses or whatever?
First thing, who do you trust? Right? You may have people in your life that you trust to make financial decisions, and those in your life that make healthcare decisions. If you're a husband and wife and your son happens to be a doctor, maybe you want him to make the healthcare decisions. And your daughter's financial advisor, maybe she's the one who needs to make the financial decisions. So name those people. As lawyers, one of the delays we have in preparing these documents is people know they want the documents. They just don't know who they want to be in charge of their decisions when those documents are applicable. So get that nailed down. And going back to change, A young couple may come in and just name each other as the person to make the decisions for each other because their children are young. But as we age, those children who are used to be 4 or 5 may be 25 or 35 or 45 and very responsible. So we may need to put them in as the primary decision maker or the alternate, just in case a spouse is no longer around or incapable of making those decisions.
Yeah, that makes sense for sure. All right. Well, thanks for tuning into Off the Record, a legal podcast with attorney Rhett Burney. For more information or to connect with Rhett, you can visit rhettburney.com. And don't forget to like and subscribe to the channel and leave us a review. Rhett, so good to see you as always. Thanks for being here.
Same here, Kevin. And I hope you're feeling well because I'm sure you haven't done anything I've told you to do.
That is true. Thanks for being here.
You too. Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.